Thanks to CuriosityStream for keeping LegalEagle in the air, which now comes with Nebula for free. Link in the description. The Supreme Court's decisions on President Trump's tax returns are in. Now remember, there is no legal requirement that presidential candidates, or presidents for that matter, release their tax returns from any particular year. But despite the lack of legal requirement, for the last 30 years, almost all presidential and vice presidential candidates have released years of their personal tax returns. Now during that time, every person nominated for the president as a Democrat or Republican has released their tax information, except for President Donald Trump. The self-proclaimed billionaire whose companies filed for bankruptcy 6 times has been extremely guarded about releasing any information about his financial status. Well, he said he would release them.
I will release my tax returns against my lawyer's wishes. I will absolutely give my return.
But then decided not to.
Well, I'm not releasing the tax returns because, as you know, they're under audit.
The financial information supposedly revealed that President Trump was deeply in debt for much of the 1980s and 1990s, and that he borrowed lots of money from overseas entities, and that in multiple years he claimed more financial losses than all but 2 other US taxpayers. Some people reacted to this news with the phrase, "So what?"
You know, the only one that cares about my tax returns are the reporters, okay? They're the only ones.
While others believe that the revelations were just the tip of the iceberg. But in 2018, the New York Times said that they obtained years of financial data about President Trump and his various organizations from anonymous sources, which we now know include the president's niece, Mary Trump, who is writing her own biography of the president. But the state of New York subpoenaed President Trump's financial records in connection with potentially the campaign finance violations that Michael Cohen, the president's lawyer, has already gone to jail over. Meanwhile, in Congress, 3 oversight committees of the House of Representatives has subpoenaed President Trump's accounting firm and multiple banks, looking for information about the president's financial history. President Trump challenged all of these subpoenas, and the cases wound up in the Supreme Court. Although the cases obviously include President Trump directly, the stakes go far beyond that in the upcoming presidential election. These decisions will determine just how much power the president, any president, not just the sitting president, has to control the legal process against the presidency in the future. And these cases are a mixed bag. Everyone wins and everyone loses. Hey Legal Eagles, it's time to think like a lawyer because it looks like some of the president's information is going to be disclosed to district attorneys and potentially the public. The Supreme Court has just decided 2 major cases regarding the accessibility of a sitting president's tax information and financial records. And what did they decide? And what does this mean for President Trump and his upcoming bid for re-election? Well, let's dive in and get down to brass tacks. This is a tale of 2 cases. The very long 2020 Supreme Court term has finally come to a close, with the court finally resolving the 2 cases involving Donald Trump's tax and financial information. So how did we get here? Well, the president claims to be a self-made billionaire.
My father gave me a very small loan in 1975, and I built it into a company that's worth many, many billions of dollars.
So why is it so taxing for President Trump to show his taxes? Well, we don't know what, if anything, the president is trying to hide in breaking with precedent and refusing to disclose his tax returns. But that picture might have been made clearer when the New York Times published a Pulitzer Prize-winning article entitled "Trump Engaged in Suspect Tax Schemes as He Reaped Riches from His Father." The article was a deep dive into the finances of Donald Trump and his father, Fred Trump Sr., as well as the rest of his immediate family. The article made 2 major findings. First, President Trump got a whole lot more than a $1 million loan from his father, Fred Trump, as the president had always claimed. Secondly, President Trump, along with his siblings, engaged in a variety of tax schemes that many tax experts said were illegal. It's a fascinating read that definitely deserves to be readdressed, especially since we've sort of moved on from this particular scandal. But some of the highlights include that not only did President Trump dissemble when he claimed that he only received a $1 million loan from his father to start his own business, which he allegedly paid back with interest, the New York Times discovered that actually President Trump's father loaned him north of $60 million at the time, or $140 million in today's money, and that he received at least $413 million in today's money from his father's estate, much of which might have been received by dubious and potentially illegal tax schemes he engaged in along with his siblings. And these schemes included potentially creating sham corporations to disguise gifts from President Trump's parents to himself and his siblings, to just undervaluing several real estate holdings in their parents' estate to avoid paying more taxes on those particular holdings. And some in the Trump family have already faced consequences from the New York Times article. For example, President Trump's sister, Marianne Trump Barry, once a federal judge, was forced to retire after the article disclosed that she and her siblings were co-owners of a shell company that allegedly siphoned cash from their father's business by just making up purchases. In addition, the inflated receipts were allegedly used to justify rent increases for thousands of tenants. Barry quit in order to stop a judicial ethics investigation into her conduct, though she did get to keep her $200,000 pension. On the other hand, the president has managed to escape scrutiny of his own taxes, largely by stonewalling the House and district attorneys who are asking for that financial information. And as a result, at this time, the public can't be certain that the president is either guilty or innocent of these allegations. Which takes us to the two Supreme Court cases that were just decided. The first is captioned as Trump versus Vance. Vance in this case being the famous, some would say infamous, New York District Attorney Cy Vance. Now, I know it seems like ancient history, but you might recall that the president's old lawyer, Michael Cohen, went to prison for tax evasion and violating campaign finance law. His crimes were paying an adult film star Stormy Daniels and former Playboy model Karen McDougal to stay quiet about their alleged sexual encounters with President Trump. Now, there's no way to know for sure, but it's possible that President Trump was the unindicted co-conspirator, Individual 1, who engaged in a conspiracy with Michael Cohen. Of course, the name has been redacted, so it's impossible to know for certain that President Trump was, in fact, Individual number 1. But notwithstanding, the district attorney for New York, Cyrus Vance, subpoenaed Trump's accounting firm, Mazars USA, for 8 years of business and personal tax records in connection with President Trump and the Trump organization's potential role in the hush money payments made to McDougal and Daniels before the 2016 election. This is a criminal investigation into President Trump's possible role in these violations of law, since Cohen claimed to be acting on President Trump's behalf.
I am ashamed that I chose to take part in concealing Mr. Trump's illicit acts rather than listening to my own conscience.
The president filed for emergency injunctive relief, claiming that as president, the Constitution provides him with absolute immunity from any criminal process or investigation, including unofficial presidential conduct and the associated subpoenas of third-party records. This means that President Trump thinks he has a right to stop Mazars and the banks Vance also subpoenaed from complying with the subpoenas. And as a result of the injunction, those financial records were never turned over to the state of New York. So let's talk about President Trump's arguments here. President Trump argued that now is not the time to bring any potential criminal charges against him. In the president's view, there are only two options for dealing with criminal allegations against a current president. One, Congress can impeach the president, which we've crossed that bridge, or a state can launch a criminal investigation after he or she ends their term as president. The president contended that defending a criminal inquiry would interfere with his ability to discharge his duties as president, and he asserted that criminal charges are actually prohibited by the Supremacy Clause of Article 2 of the Constitution, since state and local officials are simply using their authority to, quote, defeat the legitimate operations of the federal government. The president argued that it's not necessarily this one case that would distract him from presidential duties. Rather, it is, quote, the cumulative effect of permitting every state and local prosecutor to take the same steps the district attorney did here. And while the president was making it sound like there are thousands of local prosecutors waiting to prosecute the president, really he was arguing sort of the same thing that Bill Clinton once did in Clinton versus Jones, that any action taken against him would also ipso facto be politically motivated and would swamp the presidency in responding to all of these different inquiries, some of which might be legitimate, but the vast majority of which might not be legitimate and might be filed by Democratic district attorneys to stymie a Republican president or Republican district attorneys to stymie a Democratic president. In response, District Attorney Vance simply said that there's no such thing as unlimited presidential immunity from criminal prosecution. Vance argued persuasively that the president's Article 2 immunity only extends to official acts in his capacity as president. And prior precedent involving sitting presidents like Clinton versus Jones and Nixon versus Fitzgerald bolstered Vance's arguments. When Paula Jones sued Bill Clinton for sexual harassment that happened before he was president, the court ruled that he was not entitled to absolute immunity from civil litigation arising out of events which transpired prior to his taking office. And that lawsuit was not dismissed, and Clinton had to comply with the legal process. Eventually, he sat for a deposition, which he famously perjured himself. And on the other hand, the Supreme Court has ruled in the past that President Nixon did have absolute immunity from damages predicated on his official acts as president, things that happened while he was the president of the United States. But even in that case, the Supreme Court emphasized that a president is not immune from criminal charges stemming from his official or unofficial acts while in office. And here, Vance argued the same limitation on presidential immunity also extends to the Supremacy Clause, which supposedly prevented states from interfering in the president's official acts. Vance argued that state criminal investigations and subsequent subpoenas are both unrelated to the president's official acts and would not interfere with President Trump's official duties as president of the United States. And Vance also pointed out that allowing a president to have total immunity from criminal or civil litigation during the time the president is in office could lead to total immunity after one's presidential term has ended, as well as immunity from third parties. Because if that immunity existed, it might impede the criminal investigation because you might lose the evidence, or the statute of limitations might run because too much time has passed. So let's talk about how the Supreme Court ruled in this particular case. Here, Vance won and Trump lost, at least on paper. The Supreme Court ruled 7 justices to 2 that in our judicial system, the public has a right to every man's evidence. In practice, this means that the president does not have absolute immunity from state criminal subpoenas, and state prosecutors do not need to meet a higher standard to seek evidence from a sitting president. Although President Trump argued that criminal cases would distract him from his job, Justice Roberts disagreed, stating, quote, 2 centuries of experience confirm that a properly tailored criminal subpoena will not normally hamper the performance of the president's constitutional duties. And one of the things that led to people thinking that this was a complete slam dunk of a case is that these subpoenas weren't directed at the president himself, but rather third parties, accountants and banks. So it's not like the president was going to have to spend all of his time responding to the subpoenas anyway. These records are held by third parties, and President Trump cannot tell those third parties that they can't respond. And although President Trump argued that criminal investigations would harm the public perception of him, the majority opinion also dismissed this claim by noting that the issuance of a subpoena would not have much of an effect on the president's reputation. Because when you get a subpoena, you have to provide the information. There's no necessary stigma related to that in particular. Moreover, grand jury proceedings, like what was going on in New York, are strictly confidential, which, as the court pointed out, should prevent the very stigma that the president anticipates. Chief Justice Roberts, who wrote the opinion of the court, also dismissed the president's concern about thousands of local prosecutors trying to make a name for themselves by investigating the president. The court pointed out that the legal system already has safeguards to protect against the abuse of prosecutors that the president envisions. And while it's true that the Supremacy Clause bars local officials from interfering with the president's duties, if a prosecutor is attempting to usurp the president rather than simply investigate a crime, then the president can challenge that in court, which is exactly what President Trump did in this case. And while the president and the Department of Justice argued that state prosecutors should be subject to a higher standard in order to get evidence from the president, the Supreme Court disagreed, holding that it would not be proper for state criminal subpoenas to be subject to a higher standard. And the broader point was that, quote, the public interest in fair and effective law enforcement cuts in favor of comprehensive access to evidence. So if state grand juries had to meet a higher standard, it would, quote, hobble the grand jury's ability to acquire all information that might possibly bear on its investigation, end quote. The court also echoed Vance's concern that the evidence would be lost if prosecutors had to wait until the end of the president's term to see it. At the end, in this first case, Trump versus Vance, the court remanded the case back to the lower court of appeals for additional argument. In that argument, President Trump can make new arguments about the subpoenas and try to prevent the subpoenas from being enforced, but he can't argue that he is immune or that a higher standard should apply. While there are still legal questions to decide, President Trump is probably going to lose most, if not all, of the battles that he is going to have to fight in the Court of Appeals. So while the biggest battle is over, the war is not. And President Trump will probably continue to make arguments that these specific subpoenas are overbroad or make other smaller arguments about why they shouldn't be enforced. So it's possible that this issue will not be resolved before the 2020 election, though since this was a grand jury proceeding anyway, it wasn't going to be open to the public in any event. Which takes us to the other tax case that was decided at the same time, Trump versus Mazars. While Trump versus Vance was a defeat for the president, Trump versus Mazars, some argue that the president prevailed, at least because he's going to delay the effect of the decision, at least for now. This case was kicked off when President Trump sought injunctive relief on 4 subpoenas issued by 3 separate House committees: the House Financial Services Committee, the House Intelligence Committee, and the House Oversight Committee. These subpoenas were sent to Trump's accounting firm, again, as well as 2 financial institutions he used for personal and business reasons. The goal of these subpoenas, according to the House committees, is to exercise their basic roles of oversight and legislative responsibilities. Now, how would this information be used? Well, the committee said it would inform Congress on subjects like whether they need to impose new international money laundering restrictions to evaluate current ethics laws for presidents, or determine if it should be mandatory to have future presidents disclose their tax returns. And obviously, it goes without saying that it might inform past and future impeachment inquiries. Now, Donald Trump argued that congressional committees are only authorized to issue subpoenas for a true legislative agenda, not for any law enforcement reason. That would be the purview of the executive branch exclusively. And President Trump also made the very broad claim of executive privilege, stating that, quote, whatever powers Congress holds, it may not deploy them in a way that keeps the president from fulfilling the obligations of his office. Now, the House of Representatives argued that this matter had already been decided, citing Clinton versus Jones, in which a sitting president was not immune from civil litigation. The House committees argued that, quote, Article 2 does not confer on a president the power to resist compulsory process directed at him, unless, quote, there is impairment of the executive's ability to perform its constitutionally mandated functions. The House committees argued that this is clearly not the case in this situation, since the subpoenas were not even directed at the president, so there's no actual burden on the president himself. Congress argued that it has the legislative purpose for seeking information if a subpoena seeks information that will inform Congress on a subject that would likely lead to legislation. While detractors argued that these assertions were so broad that it would allow the House to seek personal information from a president about anything if it somehow could be used to justify a law. The Supreme Court ruled 7-2 in a way that sort of splits things down the middle. The court did reject President Trump's claim that he can raise executive privilege over the information, and did acknowledge that Congress has the power to subpoena information from the president so it can craft legislation effectively. However, the Supreme Court limited that power and held that congressional subpoenas are valid only if they serve a, quote, valid legislative purpose, and are not intended to be law enforcement efforts. And the Supreme Court, for the first time, articulated a 4-part test to determine if the subpoenas can be enforced against the executive branch. But just as it did in the Vance case, the Supreme Court rejected President Trump's argument that Congress needs to prove that the records are critical or some incredibly high standard. Applying such a high standard here, Roberts explained, again, he wrote the opinion for the Supreme Court, would risk seriously impeding Congress in carrying out its responsibilities. But the court also dismissed arguments by the House that these subpoenas should be treated like any other request for documents. The court held that the House did not take into account the, quote, significant separation of powers issues raised by congressional subpoenas for the president's information, and articulated that when lower courts have to decide whether to enforce a congressional subpoena into records involving the president, the courts should, quote, perform a careful analysis that takes adequate account of the separation of powers principles at stake. Among other things, courts should consider whether the president's papers are really necessary because the information cannot be obtained elsewhere, whether the subpoena is as limited in scope as it can be while still serving Congress's power, what evidence Congress has offered to establish that a subpoena advances a valid legislative purpose, and what burdens a subpoena imposes on the president. And because the lower courts did not adequately consider these factors, probably because these factors didn't exist before the Supreme Court case, the cases will now return to those courts for additional proceedings. So there were 2 crucial questions posed by the Vance and Mazars cases. First, can a state subpoena a current president's personal records as part of a criminal investigation? And the answer to that is yes. A state prosecutor has the right to subpoena a sitting president or third parties who hold information about the current president. And those inquiries are not bound by any kind of higher burden than would normally happen under a state investigation. And the second question was whether Congress can subpoena a president's personal information outside of a formal impeachment inquiry. And the answer is basically yes, but although Congress may have the right to subpoena personal information about the president, it'll need to show that there is really a legislative purpose for the information, and Congress can't necessarily do a fishing expedition into the president's personal information. In the end, the court affirmed that the president is not above the law, but the justices also kicked the can down the road a little longer, pretty much guaranteeing that we won't see the president's financial records before the vote in November. Now, I have a lot more to say about the political implications of these decisions and what it means in terms of the public actually getting access to the tax returns, but that's probably not safe for YouTube, which is why I put my extended discussion on Nebula. My creator friends and I teamed up to build our own platform where creators don't need to worry about demonetization or the dreaded algorithm. It's called Nebula, and we're thrilled to be partnering with CuriosityStream. Because Nebula is a place where creators can do what they do best, create. It's a place where we can both house our content ad-free and also experiment with original content and new series that probably wouldn't work on YouTube. In fact, if you liked this episode, the version that I put up on Nebula removes this ad entirely and replaces it with that extended discussion about the president's tax returns and all of the implications there. The bar has been set so low that rejecting these incredibly stupid arguments is considered a win. Nebula features lots of YouTube's top educational-ish creators like Thomas Frank, Knowing Better, Polyphonic, and Lindsay Ellis, and tons of others. We also get to collaborate in ways that wouldn't work on YouTube, like Tom Scott's amazing game show Money, where he pits a bunch of famous YouTubers against each other in psychological experiments where they can work together or profit individually. It is amazing. You will love it. So what does this have to do with CuriosityStream? Well, as the go-to source for the best documentaries on the internet, they love educational content and educational creators. And we worked out a deal where if you sign up for CuriosityStream with a link in the description, not only will you get access to CuriosityStream, but you'll also get a Nebula subscription for free. And to be clear, that Nebula subscription is not a trial. It's free for as long as you're a CuriosityStream member. And for a limited time, CuriosityStream is offering 26% off their annual plans. That's less than $15 a year for both CuriosityStream and Nebula. Less than $15. It's incredible. And since you've got to stay inside, you might as well be soothed by the voice of David Attenborough narrating tales about tiny hummingbirds, or join Chris Hadfield on a road trip through the universe. Or just watch Tom Scott torture your favorite YouTubers on Nebula. So if you click on the link in the description, you'll get both CuriosityStream and Nebula for 26% off. Or you can go to curiositystream.com/LegalEagle. It's a great way to support this channel and educational content directly for just $14.79 per year. That's 26% off. So just click on the link in the description or go to curiositystream.com/LegalEagle. Clicking on that link really helps out this channel. So what do you think about the court's decisions? And do you think that there should be a federal law requiring presidential candidates to reveal their tax returns? Leave your objections in the comments and check out this playlist over here with all of my other real law reviews talking about the protests and COVID-related legal issues. There's a lot going on in the law. So click on this video and I'll see you in court.